7:30, and welcome everyone. You're here for a continued public hearing of the Board of Zoning Appeals for the town of Wenham. And for those of you who aren't familiar with our process, we are being videoed tonight, both audio and video. So if you've got any reason that you're uncomfortable about that, I just want everybody to be aware of it before we proceed. And the only public hearing on for this evening is a continued public hearing, continued from September 26th. And it's a remand public hearing in accordance with Mass General Laws, Chapter 40A, Section 11. There was a remand order issued by the Land Court in the case Stanley versus Faheri et al., Land Court Case 19 miscellaneous 000137, and the Town of Wenham zoning bylaw regarding a special permit which we issued to Allison Stanley of 35 Arbor Street with conditions, allowing the construction of a barn at 35 Arbor Street. The barn has been built, or the addition has been built, but the applicant is asking that the zoning board vacate the special permit, and the applicant contends that the special permit, that no special permit is required for the barn in reliance upon an agricultural protection provision in Mass General Laws, Chapter 40A, Section 3. So we continued the public hearing to make sure that everybody had a last chance to send off legal briefs or some any additional facts that you want to have before the board tonight. The applicant has provided a brief through counsel to us, and town council has provided a legal brief to us as well. The legal brief provided to us was sent to us with the assumption that it's protected by attorney-client privilege. However, I see no reason why the board shouldn't waive that privilege in respect of the opinion, the written opinion only, so it can be part of the public record. Sure. And so I'm just asking the other members if you've got any objection to waiving.
No objection.
Attorney-client privilege with respect to the written opinion that's been provided by counsel. It would probably be a good idea to give that to counsel for the applicant as well at this point. And while we do this, since we've continued the public hearing, I guess I begin by asking, is there anything else that anyone wishes to add to the record? Since I suspect somebody will take an appeal here, just to be sure that everybody has had a full and complete opportunity to get everything filed.
Mr. Chairman, there was a document submitted to our office that is in your packet. It's by Arthur Burt. Submitted it to Missy Berry and asked her to pass it on to the ZBA. Missy Berry's the conservation agent, conservation coordinator. I had not spoken to Mr. Burt about it, but I just wanted to let you know that it's in your packet, and it can be part of this record.
Okay, I want to be sure that I'm not sure I saw that.
It's this one. Yeah, there it is. It's in your packet. I had emailed it to the board.
Did the applicant see that?
No.
Okay. Is that an extra?
Yeah.
Okay.
Okay, but this was submitted by Mr. Burt?
Burt, yeah.
It was just something that they received from the Conservation Commission?
I don't know whether it came from the Conservation Commission. He submitted it to Missy Berry on a day that I was not in the office, and then asked her to pass it on to
So
us.
that is made part of the record then?
And we gave a copy to them.
And they have a copy now.
This I have not seen.
Okay. Is there anything that, as far as the applicant is concerned, is there anything else that you wish to present to the board by way of support, factual or otherwise? Is there anything that anyone else wishes to submit to the board?
Do you want to hear some highlights of that document you have, or is that sufficient?
I think this is sufficient. I mean, I think you've heard several times from this board that the jurisdiction of the Conservation Commission is the jurisdiction of the Conservation Commission, and we leave to the Conservation Commission issues having to do with any sort of wetlands determination or anything else?
Well, there's a line there which says, Pullman notes of 38 Albert Street.
If you could just
Podium.
Just so they can get you on the camera.
Button.
If they use the microphone, so they can.
Okay. Pullman notes are from 38 Arbor Street, Wenham. The language is very clear in here that indicates that when the property being affected is near wetlands, that there would have to be a communication with the Conservation Commission. So the zoning board, I think, had heard from us that we were concerned about the wetlands there, and that should have triggered a discussion with the Conservation Commission, I would think, before you make a decision on it.
And the specific language that you want to bring to our attention on this, in this is?
Land within 200 feet of the perennial stream or river known as, that's on page 4. Wildlife habitats. So it's been discussed on more than one occasion with the zoning board that we had wildlife concerns and water concerns, pollution concerns. On page, it's marked 10. In a case like this, it would seem that we should have a civil engineer or hydrologist calculate the flood evaluations, distinguishing and delineating some wetlands and service of botanical wetland science. So I think I appreciate the fact that you're saying it's a Conservation Commission issue, but when we're discussing wetlands, I think this board should go to the Conservation Commission to determine where they are on it.
So much time has gone by.
I thought we consulted with I thought we had an email at one,
Right, I
I
wanna
could
go-
be
I wanna
confusing
go
the
back to that as
cases,
well.
but I thought we did have an email
The
saying.
work here, that being the extension of the barn, just refresh my memory, that there was a determination of non-applicability by Conservation Commission,
I
correct?
believe it was. I have to look for the, whether they sent us an email or a notice. But I've spoken to the conservation coordinator, and she has said several times that it was not in the jurisdiction based on the plans that we've received on the case.
And so, basically, because there was work that was going to be done, Conservation Commission did take a look to determine whether or not the work was going to be within the buffer zone, and they made a determination that it was not. So the only work to be done,
They made a determination, you mean the Conservation Commission made a determination, or did the clerical?
the person at the Conservation Commission charged with making a determination of applicability made that determination. So it never came with.
She's not an expert.
Okay.
It's clear from this document that the Mass law says that there should be Conservation Commission approval, and it does in fact affect wetlands, it does in fact affect vernal pools, it does in fact impact the wildlife.
I think we're still in the same place, that you should take that up with the Conservation Commission.
Okay. Thank you very much.
Anything else that anyone wishes to bring to the board?
Yes, Arthur Burt, 33 Arbor Street. I did go to the Conservation Commission. Philip Colarusso, the chairman of the commission, and also works for the EPA as a PhD in it. He stated that the wetland abutting the property at 35 Arbor Street was within the 200-foot buffer zone. which meant, if you read the law, it states that nothing can go within that 200-foot buffer zone because there's wood frogs, spotted salamanders, freshwater shrimp, and anything that does occur within that 200 buffer zone must be brought back to its original status. So it has to be removed. If the property is sold, whoever buys that property, they have to remove it. That's Mass General Law, I think it's 131 paragraph. I can give you exactly what it is. That's Mass General Law 131 paragraph 40, Wetlands Protection Act. So it does, it's been clarified by Mr. Colarusso that these buildings and other buildings are within that buffer zone.
Well, again, we'll leave that to you to bring to...
Oh, I will, there's no question. Absolutely.
It's beyond the jurisdiction of this board. Is it, yes?
And when you say within 200 feet, is that of a vernal pool?
Of where the vernal pools are. Mr. Colarusso verified, that he certified them.
We did find, there is one certified vernal pool up in that area, but I don't think it was in the 200 foot.
That's not the one he's talking about. I already checked with the Heritage Foundation.
Could be a potential, because we do have a GIS layer that shows all of the new, anything that's been certified a vernal pool. And we don't find one within 200 feet.
Well, he
of
just
property.
recently certified this. This is what he said. So what happens is they're backlogged up to Heritage. Heritage is going to get back to me. So, I mean, there's a lot of issues here. I just wanted you to be aware. Thank you.
And that's part of the record, and again, we leave that in the final discretion of the Conservation Commission. Anything else to be made part of the public record? If not, then I think I'd like to entertain a motion to close the public hearing.
Well, if we're going to have conversation with the applicant, we probably should keep the public hearing open. We can close it before the board takes its ultimate vote, but if there's going to be conversation in fairness, we should.
Okay. So, but at this point, there really isn't any, there are no factual disputes. Well, leave aside the Conservation Commission's potential jurisdiction. There aren't any factual disputes here. The question is whether or not you're primarily engaged in commercial agriculture. We gave you a special permit. We gave you the right to extend the barn. You did extend the barn. We did put some additional restrictions on about lighting and the like, and you took an appeal from that, even though you got what you asked for, and I understand, we of course understand the appeal. You've taken the appeal because you feel as though you didn't need a special permit, and that you're engaged primarily in the commercial agricultural business, and hence get the protection, and hence don't need a special permit. And the only question is whether or not the activities that you've described to us, and that are all part of the record here, and as to which nobody's got any disputes, amount to activities which fit you in as primarily engaged in commercial agriculture, correct?
Yes, for the most part, it's correct. And
Okay.
the issue is, there are conditions that are not relevant to, that are contrary to the provisions of 48 Section 3.
Provided that you get into that in the first place, and that all has to do with whether you are primarily engaged in commercial agricultural activities. Correct? And that's for this board?
That's what this board to decide, yes.
Okay. Members of the board, where are we on this? I mean, we've spent a lot of time on this.
We've seen pieces of evidence submitted to us about the purportedly primarily commercial nature of the use of the property. Is there anything more that you want to show us about the use of the property?
And I mean, the majority of the property, land mass-wise, is being used for equine purposes. There's a residence there, and there is a barn, a garage there, yes. But the majority of the volume of the land is used for equine purposes. And that includes the boarding of horses, the keeping of horses, the training of horses, and the breeding of horses.
Well, I mean, we've got testimony
Yeah,
on
we
this
provided
subject.
evidence of all that.
That it hasn't been used for the boarding, commercial boarding of horses, but rather there was a plan to do so, and perhaps there is one horse now that is half leased or something along those lines. And we've got some eggs that were sold there and a few other things. But I'm having a hard time making a determination that that means that you're primarily, I mean, it's a two-family as it is now. You've got a business in there that's the HVAC business, which you've got every right to have as a matter of right. I don't see how we get to, you're otherwise in a residential neighborhood, and I don't see how you get into a place where you say that you are primarily, and I mean by primarily, I think chiefly, more than a majority, better than 50%, you know, substantially, we can,
Those aren't necessarily the standards used in the statute.
well, the statute says primarily. How do you define it?
There is no definition for primary.
So we're gonna read it as meaning chiefly, or principally, or substantially, or more than 50%, even to give you the benefit of the doubt to say it's gotta be 51%. Maybe primarily means 75%, I don't know. But
If you take a look at the statute and you consider.
we have. No, please,
fine.
no, but I mean, to
No,
say,
that's fine.
if you take a look at the
made your mind
statute.
up.
No, please, I didn't mean to cut you off, except to say, to assure you, we have looked at the statute. We've read your briefs. We've read your correspondence. So we've absolutely read all of this. We've read what little case law there is as well. And we don't want to be in a place where we write a decision that means that, bluntly, that anybody who's selling eggs is beyond the jurisdiction, and I'm not describing this as what the only thing that you're doing, but someone who has de minimis activities in the commercial area, that somehow they're outside of the purview of the Board of Zoning Appeals.
If you're looking at relevant language of the statute, I suggest you take a look at the percentages that they look at for a facility for the sale of products. In that instance, if we're taking a look at primarily and how that is weighed, all right, if I'm having a farm stand.
Word primarily isn't there, though.
No, the word primarily, but the statute, you're focusing on primarily, and I'm telling you, the statute gives you an example.
Right.
If I want to run a farm stand, I have to use the land primarily for the purpose. What are my ratios? All I have to do is sell 25% of what I grow.
Yes.
And I can sell 75% otherwise. So there's a strong suggestion that 25% might be the primary use of the property. That's in the statute, and
Primary isn't there.
the word primary isn't there, but it's an example of the primary use that may be used of the property. If it were a farm stand, I only have 25%. So I just want you to consider that when you're struggling.
I'm certainly familiar with that, and there are folks in town who take advantage of that statute if they've got sufficient acreage. And I forget what the acreage is under that statute.
It's 5 acres, it's 48, Section 3, 5 acres, with the exception of the 2012, I think, amendment of small plot farming.
Okay. Other members of the board?
It seems to me that in that example, the other 75% is still commercial activity. Because what we're talking about here is that you've got a barn with, forgive me, 5 horses? And how many of them are your own?
You have, I believe, 9 stalls, 3 of them are leased.
Okay.
The others are used for breeding
When
mares.
did 3 of them get leased?
I believe that was the testimony that my client gave you.
Stalls. My daughter rents 3 of them from me.
I understand.
A 4th horse is one of mine that I lease the horse.
I understand. I understand. Thank you.
It doesn't add up to primarily in my judgment. What we've seen in terms of documenting what you're doing with the property in terms of commercial activities, not that what you're doing is not commercial, but to me, for it to be primarily commercial, it would have to be most of what you're doing, and then maybe you have one of your own horses in there. That would be something that would, not that that's the only thing, but that would be clear, cut and dry, primarily commercial agriculture, for example. And I don't see that. What I see is some documentation that you lease a couple stalls to a related party, to someone who's in your family, but we don't have tax records going back any number of years. We don't have, for example, and I mentioned this last time, some type of business certificate certifying your intention to operate it as a fully commercial enterprise going forward. Any number of things that, on the totality of the evidence would add up to primarily, in my judgment, and I don't see that. That's my understanding.
Yeah, no, I agree. I think also, I mean, when we first heard the special permit, which was less than a year ago, it wasn't presented as a commercial venture, and I think we keep going back to that as well.
So, I mean, can I get down to just ask the applicants? I mean, obviously, we approved the extension of the barn.
You did approve it, but you put stipulations on us that should have been put on us.
Tell me what concerns you
All
have.
the stipulations should be taken off of that special permit. We should not have had to have any stipulations put on.
And this-
Lights or this, that, and the other. We'll have the lights are on for safety. And that's that. It doesn't illuminate Arbor Street, which some of the neighbors would love you to believe. And the stipulations are unacceptable to us. That's our major concern. Plus, we would like 2 board horses there too.
And you also said we can't have more than 5 horses on the property. We've 5.83 acres.
Well,
Those are our
It's
concerns.
like-
but you know that that's the provision in the, refresh my memory, in our zoning bylaw, it's one horse per acre. I mean, that's what, but subject to,
No, state law.
1 horse per acre. If you take a look at that, the rationale behind that doesn't exist.
trust me, there are a lot of people in the room, I have 2 horses. There are a lot of people in the room who have horses. I understand you don't need an acre for each horse that you have. We all understand that. But you're in a residential neighborhood, and that's why Wenham has a provision that sort of is intended to sort of protect, on the one hand, the residential character of the neighborhood, and on the other hand, to let people in Wenham have horses, which is, historical. It's part of it's everything from, you can go and see a wonderful exhibit at the Wenham Museum right now about the history of these sorts of activities in Essex County and
But,
general.
but in applying that, you could have 2 Clydesdales, or you could have 2 minis. It doesn't make sense,
And if someone
have horse-
came to this board and asked for relief from that, I suspect this board would entertain those discussions. If somebody said, I got 7 horses, or I've got, I had 5, but my mayor just had a horse, and,
So are you suggesting that the Stanleys get rid of horses?
No, I'm suggesting that we're at Board of Zoning Appeals, and if somebody's got an issue where they need some relief, they come to the Board of Zoning Appeals.
So there are 7 horses, 6 horses? How many horses? There are 7 horses on the property.
I thought there were 6.
Yeah, let me ask you a very simple question. If the board did reconsider its special permit and allow, I better double check. Does our provision allow for additional horses by special permit or only by variance?
I believe it's by variance.
It's
I
by
don't,
variance.
So
So we'd
the-
have to have a further public hearing.
Well,
I think it's in our definitions that
Here, let
we
me-
speak to it.
I can take a look. So, do you want, because these are the conditions, if you want to look at them in a whole, and I'll look at that issue real quick.
I think if you go back to,
Right, but when you say no conditions, for example, that would delete the no living space over the,
There is no living space over.
no, I understand that, but that is one of the conditions. When you say that they would all disappear,
What?
the conditions.
No, it just says,
keeping of large animals is by a special permit.
yeah, So to answer your question, in the table of ordinances, it just says that the keeping of large animals as a density of more than one per acre needs Board of Appeals, and that's what they're asking for, is more than one per
Needs Board of
acre.
Appeals special permit?
Yes, it's BA, so it's Board of Appeals, correct, special permit, so you could do it as part of the special permit.
So, again, I'm trying to get to a practical place here. Is the issue, if, for example, the special permit were amended so as to allow, how many horses do you have right now?
On the property, we have 5 large horses and 2 mini minis.
Well, if the board were to entertain that as part of a special permit, would that resolve this?
Can we have a minute from it?
I mean, we've taken a lot of time on this, so by all means,
So would
you can
that-
take a minute, you can take.
That
We
would,
appreciate that, too.
that's a big part of it. So we could never bring another horse there besides those, though? That's the thing.
It's a number. So when you say, could you bring a different horse, the issue would still
We
be,
have another barn that we could rent out, that nothing's in. I mean,
well, I just want to make it clear that this, I don't know that we can solve this tonight, but this board, you know, would certainly entertain, you know, a request to, consistent with things that we've done before, we would entertain that sort of a request that would increase the number of animals that might be on a 5.8.
Can I have a couple minutes with my clients?
Sure.
Take a recess?
Okay, let's take a 10-minute recess. took a short recess. We're back on the record, and now we're just talking about ways that, is there some way to resolve this?
The prior special permit had 7 conditions. All right, number 1 concerned the light. All right, we are amenable to the first part of condition 1, that the lights in the front of the existing structure shall be directed as to minimize light shining into the neighbor's property, and any new lighting will be directed to minimize light onto adjacent property, period. The rest of the sentence should be stricken. Number 2, no commercial or business activity be conducted out of the barn. This barn is used for commercial purposes, so we would like all of number 2 stricken. Number 3, we can agree that we can maintain 7 horses. They've always had an excellent manure management program. The 7 horses on this property is, under these conditions, is very, very acceptable. No living space is allowed to be built within the barn. We can agree to that. That can stay. The special permit will apply to the entire barn. We can agree to that. Number 6 and number 7 are standard conditions for a special permit, and we can agree to both of those.
Did the condition about commercial enterprise of the barn relate to home occupation and whether a special permit would be required for another home occupation on the property? Was that included so as not to collide with that, given the HVAC business? I'm just trying to remember.
We never really dealt with the issue.
Right.
Right.
Yeah.
But wasn't that put in there to kind of skirt around it? Isn't that? I just want to make sure if we remove it that we don't. Cause a
5275 of
conflict.
your bylaw requires a special permit for a barn in a residential district. So I think the application just came in.
Well, yes, for the barn, but we stipulated no commercial activity. And I think, I'm trying to remember how that related to the issue of the other business that's operated from the property.
Let me look at the.
Because I don't recall from the minute, I don't have the minutes in front of me.
think that from our standpoint, we certainly didn't want to, we could take that into account in making a determination whether the property was being primarily used for commercial agriculture, that there was another business being run there, but I certainly.
Well, I think we're conflating 2 things. That's the more recent matter that we've dealt with. I'm talking when we issued this initial permit, which was the original date, I can't remember.
February of 2019.
There you go. At that time, I think we put that stipulation in because of the existing business. I can't recall exactly the thinking. So if we remove it, do we then cause a problem?
Well, I certainly don't want to be in a place where we have conceded in any way that the activities are primarily commercial activities. In other words, it will still be our position that if there are other activities that the Stanleys wanted to be involved in, they come to us requesting a special permit or a variance or whatever else, so. And the second sentence in number 1 about outside lighting shall be generally off by 9:30, except when necessary for emergencies or activities. Your concern is just that it.
Well, it usually is off by 9:30, it really is, but we just don't want to be told when we have to turn off.
Sometimes they're on later.
Sometimes they are on later.
Can't help
I mean, it all depends how the day goes, you know?
But we do build in our activities that are required during the evening hours, so that if you know, obviously, if you got a sick horse, if you got a vet, if somebody comes in late.
Yeah. Well, I mean, just 9:30 is kind of not acceptable. That's a little early, and we kind of agreed to it back when we were trying to get the special permit because we didn't know any better at that point. We didn't have counsel, which we probably should have had back then, but we didn't. So now we're at this juncture, so
Sometimes
But-
night check doesn't get done till 10 o'clock,
10 o'clock, yeah.
10:30. I wish we had a switch in the house to turn them on.
Anthony, are you taking any input into what we're doing right now, or are you waiting for a bit?
I think we're just talking. We're trying to, again, I'm trying to figure out, is there some simple way, since we've been at this now for a year, was there some way to keep the neighbors relatively satisfied and keep the Stanleys relatively satisfied? And I'm not sure that there is a way to do that, to be perfectly frank, but.
Well, the lights are a big issue. We've had luckily, two different people from the electrical people in town come to our house after dark. And literally, we cannot eat in our kitchen, eat in our dining room, and the lights light up our family room. We're talking 3 rooms from the back of our house to the front. I don't know the Wenham ruling, law, whatever you call it, the electrician has cited it to us. I don't have it written down, but there is somewhere in our bylaws it says no exterior lights can light up, this is me ad-libbing here, paraphrasing, can light up someone else's property. Our entire property, our house is right at the street, and these lights, they do not face down onto their property. They face straight ahead.
Well, we put a provision in to ask that the building inspector would, you could go to the building inspector to
We did that.
confirm whether or not
We
he's.
did do that, and that's why the electrical inspector, and also, I think he's the assistant electrical inspector, lives across the street from us, and he says it lights up his family room on the other side of Arbor Street. So the whole light issue, I'm sorry, I didn't hear what the attorney actually said about what he wanted or didn't want with those lights. But it lights up our entire house until whatever time. Our bedroom's on the 2nd floor, and we're a little bit older, we go to bed early. We go to bed by 9 o'clock, and we've just recently, again, bought room darkening drapes, because those lights go straight through our bedroom, straight through my husband's office, right to the front of our house.
Through the chair.
And this has been ongoing. and,
It's
you know,
8
the
o'clock.
light issue could easily have been fixed a year ago.
It's 8 o'clock, it's dark. Can we convene at the farm?
Not on a rainy night.
Well, it's November, but
Then can I request a continuance and to some such date, and we can convene right at the farm?
Wouldn't it be turned down?
well, I'm gonna tell you, there's 60-watt bulbs. If they're lighting up like they say they're lighting up, my electric bill would be tremendous.
I have pictures of
You're
it.
out
I
of
have
control,
pictures.
Arthur and Jan, out of control.
You attacked my wife on my front
You're
lawn.
out of control.
You attacked
Okay.
my
You
wife.
are out of
The
control.
police were
Folks.
there.
Folks,
You're out of control.
The police were there to attack, his man attacked my wife on the front lawn. The police were there, you know that. And then you harassed me after.
okay,
Yeah, that-
we're at a public hearing, and if there are questions, you've got to identify yourself, you've got to be up at the podium, you've got to direct the questions to the chair. Perhaps I went down a road here that didn't make a whole lot of sense. I do want to emphasize, and I would like to, I'd like to make a motion to close the public hearing at this point. I'd like to ask that we close the public hearing at this point.
So moved.
Second.
All in favor?
Aye.
Okay. We're on remand from the land court. And I think from what I've heard from the members, that we are of the view that the provisions of Mass General laws as respects agricultural uses would not apply to the specific facts of this case. As they've been presented to us previously and even currently, that the test of primarily involved in agricultural, commercial agricultural activities isn't met. However, I wonder if we might be able to, since we're on remand from the land court, and since we're hearing this de novo, and we're going to have to write another decision, which will reaffirm the grant of the special permit, because I haven't heard anything from this board that we're going to change that. So as to, reaffirm that the barn is allowed, but in light of the new evidence that's been in front of us, I would like to entertain some modifications to this special permit, which would recognize a willingness on the part of the board to further amend this if need be, but that we would, as to the lighting, I don't know, let's move it up to, I'd suggest that we might move it to 10 p.m. and tighten up the language as far as the importance of minimizing the way that light sheds onto other properties. That we would increase the number of horses in light of the fact that there are now 7 horses on the property, 5, and you've got a barn that will accommodate 9. How many?
6.
6.
There's 6 stalls in the barn and another smaller barn. Well, it's
On
just
the
one
property.
on the property.
It's just,
So
it's sort of a shed,
stall.
it's kind of a shed, right? So there are stalls, either a shed or a,
Yeah, the
for a
mini
total
share-
of 7 horses.
The mini share a stall.
That we'd put that to 5 horses, but we would otherwise leave all of the provisions in here, except to put some language in that recognizes that there have been activities that could be characterized as commercial, but are in the nature of de minimis activities, the sale of a horse and the like, or the renting to a family member, things of that sort, that are de minimis, and and with those changes, I wonder what the board's reaction is to those changes.
I don't see a problem outside of, I don't know how concerned we are about setting a precedent of increasing the number of horses people are allowed to
Well,
have.
we've got we on special, I mean, we're
It's just by request of special
permit.
permit. There are no
Correct.
particular stipulations around what they need to satisfy in order to do that in the
And
bylaw.
it's,
Because I have not read that part,
It's 5,
or can't recall, rather.
it's 2 mini horses, if you will, together with 5 others.
Can I say something?
Sounds reasonable.
Marge Gajewski, 7 Perkins.
We've closed the public hearing.
I don't understand, it was 5 horses, now it's 7. You only have 5 acres, 5.8 acres of land, of which some of it is wetlands. So it can't hold especially 5, but now it's gone up to 7.
Because the board has the jurisdiction to do that. We can grant, we could allow 10 horses on 5 acres if we wish.
That's my only concern, in that I need to review that part of the bylaw apparently, but I mean, I trust you that, yeah.
We've got town council.
Yeah, we got town council, exactly, so I can take that on authority that,
Unless there's a
Yeah.
separate section here that I have not seen, it's
The
literally,
definition.
yeah,
well, it's literally in the use table.
that it's just, just needs to be
And it just says,
requested.
keeping of large animals at a density of more than 1 acre, examples include horses and cows, and it just says BA.
And it also talks about large animals, doesn't it?
Keeping of large animals, and the examples are
And
horses
2
and
of the
cows.
horses, you say they're small horses.
We were told they didn't count.
Can you be more specific about what the horses are, since I'd
A
like to
large
get...
dog size.
Well, but it's bigger than that, I'm sure.
They're little.
But I mean, are they Shetland, are they...
Shetlands, yeah, they're little. What's a Shetland? That's a pony.
I wonder if that's
These are
kind of
mini
splitting hairs
horses.
at that point,
Mini
start talking about breed.
Say pets.
Got it.
Maybe
There's another
shorter
section,
animals.
yeah,
Okay.
yeah, there's parking and loading.
Anthony, are we still talking? Because I just have a question.
Sure.
I don't remember which meeting, but whenever one of the barns was built, the board said they only could have their horses there. they couldn't run a business with horses.
That's the provision that we're struggling with here, that we're saying that no.
So now if they run a business with horses, whatever you call that, is that now 2 businesses? Is that now actually 3 businesses on the property? Because I gave you the paperwork that there are 2 businesses certified with the Commonwealth of Massachusetts.
We
on the
understand
property.
the question, and and we'd be working on that language so as to make it clear that where someone is renting stalls to a family member, for example, that is a de minimis commercial activity, and an activity which involves a half leasing of a horse, a pleasure horse, would similarly be in the nature of a de minimis, a not consequential commercial activity that would violate Section 2.
If you're renting a stall to a family member, you're like their daughter rents stalls.
No, like Mrs. Stanley rents 3 stalls to her daughter.
I think what they said at the last meeting was their daughter is renting stalls to outside people.
No, the way that this is presented to us is Stanley's daughter pays Stanley a monthly fee of $150 to rent 3 stalls, and for her horses.
That's the girl that leases a horse. She pays $150 a month to lease my horse.
That's not their daughter, that's someone else.
Devin pays much more than that to rent 3 stalls.
Okay, but it's still a family member. Okay, well, this may, I'm reading what's in the...
And that was based on what I took from the last meeting, which they
So
didn't
nobody's
correct.
horses are on the property unless they are owned by Devin or the parents. Wrong?
No, hold on. The way you've asked the question, that would be correct, because the horse would be owned by Mrs. Stanley, even though it is, there may be some arrangement where somebody can come over and ride the horse from time to time, half lease or something along those lines.
At the last meeting, they said they owned half and their daughter owned half of the horses, was my understanding.
No, there was a horse that was sold, the sale didn't work out in one fashion or another, and that there's someone who's now,
But they still own the horse.
but you still own the horse.
Yeah, that was what I was saying, that all of the horses are owned by them or their daughter.
So there are no horses being boarded there that are owned by anyone else? At the last meeting, they said they were boarding someone else's horse.
There was a suggestion that they planned to do that, but right now, that's exactly where things are, just as you've described it.
So how would anyone know who these
Oh,
horses belong to?
it's a very difficult question.
Well, it is, it's the same question as
It
the
is.
daughter still lives in the apartment that you said they can't use. She goes out to work every day, she comes home every night, in the apartment that she's not supposed to be living in. How much more can the neighbors take?
We deal with this all the time, where we put a
I know
restriction
you do.
on, and someone, and the building inspector, unfortunately, it's part of the building inspector's job to figure all of this
No, he
out.
went there. But, he can come to my house and say, okay, you can't rent that, whatever, and I take the bed out, and 3 days later, I put the bed back.
I understand.
It's a hard.
Well, we've had the building inspector there on numerous occasions, and all we can do is take what information the building inspector. I'd like to, again, entertain that motion to make those, subject to the board's further review of a draft of this decision, to revise the special, to deny the request that's been made with respect to the application of the agricultural use provision, but to modify the special permit that's been granted in accordance with the discussions we've just had, and subject to the board reviewing draft language. And let's again be careful about the way we're going to draft that. We're going to do a draft of the decision. We're going to submit that to the members of the board.
Yes.
And we'll not talk about it
Not at all.
with one another until we get together again at the next
Oh,
hearing.
absolutely.
Correct. So those are the ground rules on that.
And I will remind the board that under the remand order, we have 30 days to file the decision.
From the date that
That you
we
close the public
close
hearing.
the public
So
hearing.
from
we
today. So just to be
close the
mindful of
public hearing.
scheduling.
So let's talk about schedule. When can we have another meeting for the sole purpose of going over, the only purpose will be to
The
go
draft
over a
decision.
draft decision. We got to do better than we did the last time.
All right, so,
We were fine.
Weeknights usually work for me. I don't happen to have my phone today, but
Yeah.
unless I'm in the car, I think.
Do you want to grab it, just, or?
I'm
You think you're
not sure if
pretty
it's at my house or
Oh.
in the car.
How does the week of, let's see,
Well, we got to get a draft decision, so, you know, it's going to be after Thanksgiving. How about the week, that first week in December? The 2nd, 3rd, 4th. The
Yeah, that
Thursday I
works.
can't do.
I can't do Thursday, but I can do the 2nd.
Well, I want to start with the board. Monday, Tuesday, Wednesday, the 2nd, 3rd, and 4th of December.
All open for me. They're all
They're all
fine.
of it?
Yes.
They're all free?
Yep.
The selectmen meet on the 3rd, but that doesn't prohibit us from having a meeting.
The selectmen's meeting on Tuesdays.
Or the 3rd, okay.
The second-
So do we do Monday, the 2nd,
Monday the 2nd.
Don't see anything.
and 7:30?
Yep.
All right, so Monday, December 2nd, 7:30.
7:30.
All right, and that will be to discuss the draft.
Discuss the draft. And the way that we often do this, and the way we'll do it in this case, is that once we've put a draft of the council, and I have put a draft, and Margaret have put a draft of a decision together, at the same time that it's sent off to the other members of the board, we'll post it as a draft on the
Town website?
town website. And so, and only then at the hearing, when we get together again, that's the only point at which we can talk to each other about it. We can't share information, although each member could provide comments to Margaret, and we would certainly entertain any comments that came in from you if you directed those to Margaret as well.
And then I will bring all of those.
And you'll bring all the comments,
to you
right.
at the next meeting. Okay.
So written comments would be okay? I'm in.
Yeah, just mark it up, just marked up, just,
I'm in Lancaster on.
I understand, yeah, it's just whatever, again, I'm not saying we'll accept them, but anybody who wants to make comments on it, we'll take a look. Oh,
Mr. Chairman?
yes.
Clarification, when the attorney spoke on behalf of the applicants, he indicated that they agreed that there would not be an apartment in the barn. That's not the question. The apartment is in the garage.
Well, of
That was a
course, we've already,
condition of that permit.
that's a prior condition that we've, a prior decision. I'll cross-reference the prior decision that makes it clear that there won't be any living space in the barn, and subject to prior decisions of this board, there won't be living space in the area over the garage. That we're not making any modifications in that.
So there will not be any
So moved.
So just to be clear what you're voting on
Yeah.
Yes?
now is, well, what are you voting on?
We are voting on having been sent back on remand to do de novo, start it all over again, de novo review of the special permit that we granted. We have just indicated by vote that we are going to amend the special permit, consistent with the discussions we just had with respect to paragraphs 1, 2, 3, and I guess we'll put in 4 as well of the special conditions, since we'll bulk that up and make it clear that the area over the garage will not have a living space either. And we will, consistent with what the board has voted, deny the request of the applicants to make a determination that the property is primarily used for commercial agricultural activities, and hence outside of the purview of this board.
All subject to final review on 12/2 at 7:30.
Correct.
Okay, perfect.
Mr. Chairman, if I could ask. Mr. DeLuna requested that special condition number 2 be stricken.
I do understand that. And
Did you determine to do that, or?
no, we're going to modify that, and to make it clear that the activities that they are involved in are de minimis, because I don't want to be in a place where they somehow or another, the activities that we're now familiar with are somehow prohibited, that you know, the sale of some eggs and things of that sort are you know, $2,000 and the like. It is so de minimis, I don't want to be in a place where we're restricting everybody in town from being able to sell a boat, you know, off of their property or something along those lines, and have someone say that's a commercial activity.
Gotcha. Okay, thank you.
So I think we've taken that vote now, yes? Did we?
No, I made a motion to that effect.
All in
seconded.
favor?
Aye.
Aye.
So then
Okay.
just a motion
So-
just to continue.
I guess I'd also like to ask for a motion that we continue the deliberations to 7:30 on December 2nd, same venue, Town Hall.
So moved.
Second.
All in favor?
Aye.
The ayes have it. Okay, we do have a couple of additional things on the, on our agenda for this evening, if anyone wishes to stick around for that. Those include review and approval of minutes. Now, I don't think I've reviewed those minutes
I
yet.
haven't yet either.
No?
So
Wanna hold them?
I want to take
Yeah.
one more look at them.
All right, we'll hold those till
Town meeting,
next meeting.
coming up.
Can I put those on the December 2nd meeting?
Sure.
Yep.
Yeah, there's two items, let me just write this down so I don't forget. As you know, we're getting close to the time to start to discuss town meeting, and if there are any zoning amendments that anybody wanted to bring forward. We've had some discussion in the office about some items that we may want to have some discussion about. This board is not responsible for submitting zoning amendments.
Planning
but-
board.
Yeah, but we will bring you into the discussion. What I did want to tell you, though, is we have applied for a grant through the Municipal Vulnerability Preparedness Action Grant for funds to revise all of our bylaws and regulations over the next year. We've found that some of our regulations aren't in compliance with some of best practices or, you know, climate adaptation policies, and that there's some inconsistencies between our different regulations. So we have our fingers crossed. We sent the application in on last Thursday, and we have our fingers crossed that we will get those funds. Once we do get them, not if, once, that process will begin. We'll have this board involved. We plan on really pulling everybody into that process over the next year. But town meeting in 2020, you know, if there are any zoning items that we feel are very important
Where
that
are
we
we
need
with
to-
the Airbnb issue?
You know, I
It
don't
got
know what
kinda
happened
tabled?
with that. It's been tabled, but with the governor's new law on Airbnb gives us the ability to collect some tax revenue from them. I think the town, in the selectman's office, they're looking at that, to bring that forward to town meeting, to adopt that provision, so that we can take some funds from Airbnb. That being said, the only other things that we think might be important to do this year is, we talked about possibly rezoning Boulder Lane. You know Boulder Lane
Yeah,
down at the end, that nobody wants to build anything on? That, you know, possibly if we brought that forward at town meeting to rezone, it might be easier should someone be interested in developing it commercially. But that's just the thought that came up in some discussion. There may be occasion that we need to update our stormwater regulations to comply with our MS4 permitting. It's just those kinds of things. We don't see anything,
Paper streets makes
Yeah.
me nervous. What are they thinking of doing with paper streets?
well, paper streets we had brought forward last year to discuss. There's that provision in our bylaw that has created a little bit of issue with the subdivision rules and regulations and reducing the size of streets and frontage requirements and things, so.
Whatever happened with that piece, that property where they were going to build the 50-foot cul-de-sac? It was.
Arbor Street.
Up on Arbor.
Yeah.
We have not heard back from them.
Good.
Okay.
They did say they may come forward with the standard subdivision for that property, but we haven't seen that, so we're not sure where that is. But that's something that we do we will bring into the discussion, but I think for next year. That will be part of that whole discussion, once we start to really look at all of our regulations, to see how the subdivision rules and regulations correspond to zoning, how those correspond to general, and how those correspond to water resources, and to look at it, especially through the eyes of sustainability and climate adaptation going forward, so. But just something I wanted to put on your, kind of on your radar screen.
There, I saw the add parcels to cell tower overlay.
Yeah, that was something too we discussed, just potential, because over in that section of town, we still have a kind of a gap. in
Which
some-
section is that?
Center of
West-
town.
West Wenham, no, not
Oh,
here.
West Wenham,
West
yeah,
Wenham.
Listen,
definitely.
I'm over there with Joe Haley at 214 Main Street, and the
Yeah,
phones
there
don't work.
too. No, there's a lot of gaps in coverage.
Yeah,
in
there
town.
are still gaps in coverage, so those are discussions that we're gonna have too, I think over the next year, based on small cell small cell things, and, so those are all discussions that we are gonna have. But I know there is still gaps in service.
Yeah, we're in a dead
There
zone.
should be an antenna in, Verizon does have a permit to put their antenna in the steeple.
They haven't, right?
They haven't done it yet. They keep asking for an extension on that permit, so, but I think that's an internal funding issue with Verizon, and, you know.
And our 40B project?
No final word yet on where that stands. I'm waiting to hear back from,
I'll shoot another note off to Ted Rignanti. I mean, last I knew, they were just getting their approval as far as money is concerned, right?
Yes, I'm sorry. The Affordable Housing Trust did sign off on their loan agreement, as did the Community Preservation Committee. So they will get that funding, but there are other steps that need to be taken still. It's the Harbor Light and the neighbors, the people who appealed it, have still to come to their final conclusion, and then it's still to be determined whether it's remanded back to this board, or how this board's gonna get that application back with the amendments, so. But, we're hoping that comes soon, I think. So, yeah, but just to have, kind of on your radar, that we'll be looking at zoning and town meeting coming up pretty soon. Maybe December, and then the planning board's public hearing, if there are any amendments, will probably be in January.
Any houses sold over at the golf course yet?
Not yet. No.
But they are building more.
They do have permits for 4 buildings, and they have foundations, and one's complete, and that's a 2-unit building. One of them is almost complete, and the other one's started, and there's one that has foundation. And yeah, we're not sure where that's gonna go, but we'd like to see them sell some. We just haven't seen that happen yet. So, but other than that, there isn't really anything else that is important happening. I don't have any new applications at this time.
Okay.
I haven't heard of anything new coming in.
Like to
So,
entertain a motion to adjourn.
So moved.
Unless you've got
Seconded.
some other things that are important.
wonderful.
Unless, have you got anything new in town that you want to bring up?
No,
No.
nothing new.
All in favor?
Aye.
Aye, the ayes have it.